Casualty events, very infrequent, but when it does happen, you got to know what to do. And this could apply to when a construction worker has a beam fall on their leg. They have a little eight eight point checklist when something similar happened in the past. After a certain number of years of owning X number of properties, I almost guarantee you're going to have some type of casualty event. Now, the main three risks are water damage, you have fire, and you have wind damage. And I get this question a lot. People are like, oh, what about like hurricane coverage or tornado? And I said, well, those are not really specific events. You do have natural disasters, but that's maybe more under a force majeure definition or excuse of performance. But in terms of these risks, those natural disasters are really boiled down to these three types of damage. I guess I got snow in there, but snow is different one. I guess you could have a load bearing issue with heavy snow. You could have roof leaks, which are water damage. That's kind of a structural damage, but that's still very common under casualties, just like if a car runs into you or a tree branch falls on your building and crushes it. But the reason I say that is because it's important to understand how to view it in terms of segregating the damages from each of the portions. So, what portion of the damage is attributable to water damage? What is attributable to wind? And when there's a fire in your building, I think I just had this conversation with somebody else for an apartment in Dallas. They dumped something like 1 million gallons of water on this multifamily construction. The water damage from the fire department was worse than the fire. And that is super, super common. Is that covered under some insurance, or how does your lease treat that type of damage? So after those events happen, you typically have one of two choices. You can repair the building, you can get your insurance proceeds, you can hire contractors, and you can repair the building. And then the question is, can other tenants, because oftentimes, again, a fire may occur on one end of the building, what happens to the other tenants on the other side? Now, there's kind of some boilerplate or very common language which says if damage is greater than 25% of the building, all of the tenants can terminate their leases because essentially what they signed up for is no longer the same. It's materially changed. And so if that doesn't make sense to you and you want to say, even if there's only one unit that is able to operate, I want to keep that tenant in, then that becomes maybe the landlord's choice to terminate. Because again, on the flip side, it's harder to conduct repairs on 20% of the building if all of the tenants are there. And maybe 20% is too low, but if it's 50%, you may want to kick out that other 50%, have the right to terminate their leases so that you can repair the entire premise in one shot and do some other repairs at the same time. Destruction. So if the building is condemned, and this is, pretty significant losses, you want to understand who holds the rights to terminate the lease and who maybe decides whether a building's damage is a complete loss. Yes, so Zach asked the question, does insurance kick in monthly rent in this event? And the answer is if you have the right type of policy. If you have, business interruption, there are different types of casualty coverages that distinguish, say, between terrorism, right? There's like domestic terrorism versus acts of war from like a recognized country. And then there's like natural disaster type wind and rain, and those are all different. You've got to maybe just talk to the insurance broker. So types of insurance, you insure the property, you have business interruption, which is the rental income. Natural disasters is again, that's distinguished from intentional acts that are considered crime or terrorism. For better for worse, they distinguish between those types of acts. Same for a tenant causing some type of accident. They have some explosion, or a lot of these fires, I would say, happen from tenants. So they have some type of oil, some lubricant, they have as a spark, it catches fire. A lot of tenants have risky operating procedures. their whole space just goes up in flames and then the drywall catches and policy review. So highly, highly recommend that you understand at least the bullet point coverages on your policy. So look at your ACCOR forms, that's ACCOR, and just be able to understand what's on that form because if you if you're holding a building for the long term, you want to make sure you are not overpaying for insurance, but also not underpaying as the replacement costs go up, but also as the age of your building goes down, you're kind of more inclined to take more risks. I think you buy less insurance the older your building is. When you have a casualty event, you have to incorporate a checklist. Post-casualty response. This is where, we can really help out the most. I think you've got to make a list of your contacts. Who do you contact when you get that phone call from a tenant or a property manager says there's a fire, fire trucks are here, there's a fire marshal that wants to talk to you. Can I give him your phone number? And you say, yeah, yeah, yeah. You got to make a list of what do you do when that happens? If, especially if you're off site, if you don't live close by, you notify the PM, you notify your insurance, you notify your lender, you've got to notify your other tenants. You've got to have a plan in place for evaluating the pieces of the building that are affected and what you want to do afterwards. So there's just kind of a checklist that you have no idea what the scope of the fire is. So maybe you need to ask for photos from somebody that can stand back and kind of give you a rough estimate. Um, there's just a lot of parties to notify, and I think if you don't have a checklist, it's likely to forget one of them. But one of the big questions I get too, on that assessment and documentation, what happens when there's a dispute between the lender and the owner? And I don't have a great answer for it, but it goes something like this, where a portion of the building is damaged or a significant portion, but you as the owner say, hey, that's no problem. I'm going to get the insurance proceeds and I'm going to rebuild. And the lender steps in and says, no, we think that this building is demolished. It's a casualty loss, a complete loss. We want you to take the insurance proceeds and pay us off. um, who gets to force the hand? And it's not always clear to me where if the collateral is impaired, but it's not your fault as a borrower. If you keep making those monthly payments, why does the bank get to tell you to force you to pay them off if they still own the dirt and you're still making payments? You're not in default because it wasn't your fault. I don't know if that makes sense, but most of the times default has to do with an act or a failure to act, an omission of the borrower. It has to be kind of something within your control that you did or didn't do. And with the casualty, it's hey, it really wasn't my fault. Why should I be defaulted on my loan for something that I could not have prevented? So that's kind of an important question that if you're looking through your loan docs, ask your lender or look at the clause where it has to do with a forced payback with an impairment of the collateral. Because I'll tell you, if you go down that rabbit hole, and some of the loan docs I've seen that quote force that repayment, they have very broad definitions of what's an impairment of collateral. I mean, that could be something as simple as a neighbor moving in next door that, has a smelly operation. Well, why does that impair my collateral? It's not my fault. Or what if they narrow the road in front of you or something like that? There's all sorts of weird rules that the bank could suddenly decide that, oh, this is impairs your collateral. Even though you've been making payments on time, we see a reduction in the value. And so we want you to pay off the loan ASAP. It's a very slippery slope of what that definition of impairment of collateral, and short of saying it's a complete loss, the building was pancaked, that's kind of open for interpretation. So you don't want to be fighting with your lender at the same time that you're trying to fight with insurance company and contractors and getting bids to repair. If they see a little corner of the building that gets damaged and they say, oh, that's an impairment, we want you to just pay us off in 30 days. That's kind of unreasonable. I just say this again to be aware if somebody is watching this video frantically at 1 a.m. contact your lawyer, read your leases to understand what the consequences are of varying levels of condemnation and what that threshold is. Is it 25%? Is it 55%? Is it 10%? uh, Documentation, photos, videos, inside, outside. You want to look at the building from 360 degrees. Maybe you get a drone up in the air. Whatever that is, you need to understand what your leases say and how much time you have to make a decision. There's also repair thresholds. Sorry, there's often also repair thresholds, which says that if the landlord could repair the building in 120 days, all the tenants have to keep paying and you don't get to terminate the lease, no matter how bad the casualty damage is. Communication, again, you should be doing this through your PM. Maybe you have a CRM set up, but telling everybody what's going on, what the steps are, even if you don't know what you're going to do, telling them what the steps are and what information you need before you can decide what to do, super critical. And I think that the tenants will really appreciate that type of communication. And finally, it's just continuous improvement. These types of events will happen to you maybe during construction, maybe during lease up. The way you make decisions should try to be documented as a policy or a procedure, continually improve upon. Because I think the whole goal in this is to improve yourself in your decision making process. You look at some of these old veterans and something happens to them and it doesn't stress them out at all. They just take it in stride and they make the best they can. But I think the reason that they're able to do that is because they have a little eight point checklist when something similar happened in the past. And this could apply to when a construction worker has a beam fall on their leg. They say, oh man, that sucks. Well, this is who I need to notify, blah, blah, blah. These are my checklists. Oh man, a tree fell on my property, or a drunk driver crashed into my building. Those are all similar but different type of casualty event. And they have varying degrees of consequences and trigger different clauses and different insurance and different remedies. But the point is, once you've seen one of those things, if you write it down and if you just think about what you want to happen and you stay on top of communication, you're going to be much better prepared when another casualty event happens in the future. So that's kind of just my point about this is the best people incorporate lessons into the future prepared plan. So, all right, guys. Well,
Awesome.
thank you very much. Have a great evening. I'm signing off. Well, again, we'll edit and we'll post this online. Thanks, Kyle. See you, Kyle.
Bye.